Welcome to the second episode of Call to the Bar, International Law Over Drinks, a series of casual conversations about current issues in international law, life in academia, and whatever else is on our mind. In these conversations, we're speaking off the cuff and without benefit of footnotes, and nothing we say should be taken to have been thoroughly peer-reviewed. I'm Douglas Guilfoyle, Professor of International Law and Security at UNSW Canberra, and today I'm joined by Dr. Tamsin Philippa Paige, Senior Lecturer at Deakin Law School. Tamsin is widely known on Twitter or X or whatever we're now meant to call it as international law's cool queer aunt, and is the author of the splendidly titled Petulant and Contrary, Approaches by the Permanent 5 Members of the UN Security Council to the Concept of Threat to the Peace. Tamsin, before we get down to all the bad takes on Security Council reform and powers doing the rounds, first question, what's your drink?
I have a tea here today called Milamar Black. It's from Milamar Tea Estate in the Kenyan Highlands in Western Kenya. It's not my usual tea. I'm normally more of a Darjeeling, Assam, or Oolong girl, but I decided to go with this, and it's the first time I've tried it. And really beautiful golden color, a little bit malty, very mellow. 10 out of 10 would recommend anyone to pick it up. Gorgeous tea, and I'm having it in the beautiful Tea for One set that my partner got me when I got promoted from Royal Albert. It's a little pot and cup and saucer in the old country roses pattern from Royal Albert. And what are you having, Douglas?
Well, in solidarity, I'm also having tea, a bit late in the day for caffeine for me. So I'm indulging in a sampler set of South Korean teas I was given a while ago. And what I'm drinking is apparently in English balloon flower tea. It's kind of a fairly sort of mid-browny orange color. It's not unpleasant, but it's got a much earthier taste than I'm used to in herb tea. And normally, from your list before, if I'm having tea at the desk, it's normally Assam. Okie dokie.
Beautiful.
Now, as listeners are hopefully getting used to, I like to begin each of these episodes with a little bit of background on our friendships and career paths. Now, as far as I can recall, and you're very welcome to correct me, we must have first met around 2010 or 2011 in the course of your MPhil at the ANU. Would you like to tell your version of how we became friends?
Yeah, so you're pretty spot on. So it was 2011 when we first corresponded. I was preparing my research proposal for my MPhil, and I wasn't certain who in Australia to get to supervise. And your name came up in all of the literature on pirates a fair bit. And I Googled you, and you're like, oh, you're from Australia. So I cold emailed you my research proposal saying, this is what I want to do for my master's by research. Who would you recommend in Australia? I get asked to supervise, and you very kindly read my proposal and then sent me a list of names for people in universities in Australia who would be qualified to supervise that. So that's how we initially corresponded. We first met kind of about 9 to 12 months later when you were giving a talk at the ANU, where I ended up doing my MPhil on Somali piracy, and we had coffee before, during the morning before you were giving the talk, and you said, yeah, don't bother showing up to my talk. You already know everything I'm going to say. Don't waste your time. We had minimal contact between then because you were going to be examining my MPhil and we didn't want to create a conflict of interest. But after the examination, where you gave it a glowing outcome of pass without corrections, thanks for that. We just kind of kept bumping into each other and had an 8-year disagreement over the interpretation of private ends in UNCLOS to find out that we actually agree we were just focused on different issues when we started co-authoring together. So yeah, through academia and pirates. And a bit of perfidy from you from saying that you don't do field work and then showing up at Ansel with photos of you doing field work.
Yes, I have a long-running joke that I'm a desk scholar who refuses to get out into the field, and I leave that to far more capable people like Tamsin. But that precise Ansel panel that I think you're thinking of was probably also the first time I met Dina Suvala, who will hopefully be co-hosting episode 3.
Yes, we shared a panel when you were talking about Chagos Islands on that one. Then later in the day, you had one for the objects in international law on the Somali piracy skiff, and then I see you having fieldwork photos, and I literally mid-session just yelled out perfidy.
I recall there weren't a lot of people who laughed at that. It's not something that's usually yelled at an academic conference, but I was definitely one of them. I was, yeah, absolutely howling. All right, so second sort of starter question for our early career listeners. Could you perhaps say something about how you got into international law and the career path that has brought you to your current job?
Yeah, so I'm a fairly non-traditional pathway academic. I came to university as a high school dropout who left high school early on and became a chef and then fine dining patissier. So did that in Sydney restaurants for ages till I got bored, and then enrolled in a Bachelor of Arts, having no idea what I wanted to do, and did that part-time while still chefing, and double majored in sociology and English literature. And doing sociology sent me to law, and doing law sent me back to sociology because all the things I found interesting about law didn't happen in legal practice or study. They happened in sociology of examining what law does in society, which is how I then moved into research on Somali piracy and then UN Security Council stuff, and then a whole host of other bits and pieces that I do now. How did I get into international law? Well, I like big boats and I cannot lie. So I wanted to take law of the sea as an elective, but I needed to do public international law to take law of the sea. So I did public international law, and it was taught by Stan Palasis at UTS. And we had a beer later, kind of after when I was in my MPhil, and he's like, he could remember about week 3 when he could see it in my eyes when suddenly international law clicked as to what was going on, and I fell in love. And that's kind of how I ended up going, oh, international law is really fascinating. Particularly for me, it was the Hungary-Slovakia dams case. I'm not going to try and pronounce it because my Eastern European pronunciation of the different languages.
Gabčíkovo Nagimaros. I have
That'd
no
be the
idea if I
one?
pronounced that correctly.
Yeah.
Giving lectures when I was at UCL in London, I had to invent a pronunciation I could deliver consistently and convincingly. So I just always went with Gabčíkovo Nagimaros.
Yes. And so that reading that case and having to present on that case in undergraduate international law made me realize that when international law comes into play, it's because some motherfucker's stolen a river. And that made me just like kind of go, whoa, okay, this is really cool. And it kind of blossomed from there. What I wanted to do was law and fairy tales, but I knew I wasn't going to be able to sell that to a hiring committee. So I put that on the back burner and went with my second choice, which was empirical studies on international law, until I got settled in a permanent position where I had the freedom to then expand into law and literature and law and fairy tales research as well.
Yep. Yeah, and I think it is interesting and something we may come back to in later discussions, the way you straddle a number of interdisciplinary boundaries between law and sociology and also law and literature. And while I know you did your BA and law degree separately, something that listeners outside of Australia might not be familiar with is that in Australia it's very common to do law as a kind of combined long undergraduate degree with another discipline. So I actually think Australian international lawyers usually come to an interdisciplinary perspective on international law reasonably comfortably, but very much obviously informed by whatever their other undergraduate discipline was.
Which is frequently history or international relations, very rarely sociology or English literature. The other thing I would say is, like, because I saw this in a little bit of a meme today of, don't chase your dreams. Humans are persistence hunters. Walk them down until they give up and lie down. In other words, be patient and be strategic. Keep the dreams in sight and keep walking towards them. Don't get discouraged if they don't occur quickly and rapidly.
And look, I think that really chimes with something Juliet said last episode about, well, if your first choice isn't available, what's the next thing that is nearest or kind of near?
Exactly, and that's kind of where I went. I knew that doing my MPhil and my PhD in law and literature would be a hard sell to a hiring committee at a university because it's hard to get them to recognize the value, the immediate value of that research. Research on how international law was being deployed in security situations. Yeah, that's an easy sell. And it was my second choice. So I pursued that first and put the law and literature on hold until I had more security and I didn't have to justify it as much to a hiring committee. And that may seem really cynical, but it was necessary for me.
Yep. No, and I think that's solid advice to everyone. And I had a conversation with someone this morning where they said, well, how do I balance my priorities? And I said, well, it's a question of what's in your interests. And I mean that in two ways. Like, what are you genuinely interested in as a scholar, but also what is in your career interests in the short to medium term. But you've mentioned the word security. So let's move on to the main event. So the Security Council and the veto power wielded by each of its 5 permanent members is seldom out of the spotlight in public international law. So recent controversies, and I'm sure I'm missing many, but have included Russia vetoing resolutions on the conflict in Ukraine, the US vetoing both early ceasefire resolutions regarding Gaza and the General Assembly's recommendation that the state of Palestine be admitted as a full member of the UN. So this has led a number of academics to variously ask such questions as, is Russia really the successor to the USSR seat on the Security Council? Could we reform the Security Council veto power? For example, could permanent members be prevented from vetoing resolutions regarding their own actions? And finally, could the Security Council's role in admitting member states to the United Nations be circumvented so that the state of Palestine can be recognized as a full UN member state despite the US veto in the Security Council? Now, before we get into any of that collection of intriguing takes, Tamsin, could you do 2 things for us? One, could you remind any listeners who aren't complete international law tragics, and I'm sure there's at least 2 of them, why the Security Council is important? And second, could you also explain why you think the usual Western criticism that the Security Council would work properly if it just weren't for those pesky Russian and Chinese delegations is wrong?
Okay, on the first point, the Security Council is incredibly important because of Article 2.4 of the UN Charter, which is the prohibition on the use of force. The prohibition on the use of force can be overcome by Article 51, and I'm not here to talk about Article 51 self or collective defense mechanisms, except to say that it's only preemptive self-defense if it's from the preemptive region of France. Otherwise, it's sparkling aggression. And it's same with humanitarian intervention. And beyond that, the only other mechanism we have for a lawful use of proactive force is an Article 39 determination of threat to the peace, breach of the peace, or act of aggression, followed by, I want to say off the top of my head, Article 42 measures for use of force by things. I haven't got the UN Charter in front of me, so that was just off the top of my head. I've been told by Douglas it's correct with a big thumbs up, so that's helpful. So that's the importance. So the maintenance of international peace and security sits with the Security Council through that process of Chapter 6 and Chapter 7 resolutions, and particularly the legality of the use of force only being able to be achieved through a Security Council decision, which by virtue of Article 25 is binding. Now, usually Security Council decisions are made under Chapter 7 explicitly, but they don't have to be Chapter 7 resolutions. It doesn't require the operative paragraph to say deciding under Chapter 7 of the UN Charter. It just needs to say that they're deciding something, and it's legally binding on every state in the world.
So to sum up on that point, putting aside any number of exceptions that people have argued about, just looking at the Charter, the only way you get to use force in international relations legally is either Article 51 self-defense or the Security Council permits or encourages or calls upon states to do it under Chapter 7. That's it in a
Yes.
nutshell, right?
And they usually frame that as not there's the use of force, but they frame it as all measures necessary. That is the euphemism for go blow some shit up.
Right. So,
Do you want me to move on to the Western criticism?
yeah. Just by way of leading into that. So, I mean, where we've got to is that within the UN framework, then, it's fairly common when sort of teaching international law to kind of go, well, the Security Council is the enforcement arm, right? If something is going to be done to use force, you've got to get the Security Council to do it. And the conclusion that a lot of early students of international law then reach is, oh, wow, the whole thing would work if it weren't for the veto power wielded by the 5 permanent members. And if it weren't for these states that hold contrary political opinions to me, the whole system would just function. So with that, over to you for your reaction to that take.
Well, I mean, that take is just frankly terrible, because that take is just advancing my preferred nation state's imperialism. The whole point of the veto is if you can't get these 5 groups that mostly hate each other to agree on something, you can't do it. And now here's where we go into a bit of thing. I've just finished a paper. It's with for an edited collection on global governance. I've wrote it with my PhD student, Joanne Stagg, and it's with the editors who are Aoife O'Donoghue and Ruth Hutton, on looking at utopian and dystopian fascisms and democracies as well. But the one we look at in terms of this utopian and dystopian fascisms is the Security Council. The UN Security Council is set up on all the ideals of utopian fascism. It elevates a group of people above everyone else who have no accountability to law and gives them the power to maintain strength and peace for everyone through unity and making them, putting them in a position of privilege. And that's what we have in the Security Council. They're above the law. Simon Chesterman and Jose Alvarez and myself have written a fair bit on this. And they can do whatever they want if they all agree to it and don't veto it. So the veto is the only check that there is on naked ambition in terms of global imperialism through the Security Council. So it wouldn't work if it weren't for those pesky people who I don't agree with vetoing things. It's working because they're vetoing things. Is it fair? No. Is it a good system? No. Would it be worse if you just removed the people who you don't agree with? No, it would definitely be worse. It would not be better, because it would just amplify colonialism and imperialism from great powers. And I mean, there is a huge argument that it shouldn't have been set up to allow them to veto matters that are affecting them or that they are a party to. I agree. But it was, and that was kind of one of the conditions that these powers placed on taking that role, was that they get to veto anything.
Right. That was the price of having the major powers at the end of the Second World War inside the tent. So, okay, so you've touched there on, it was debated at the time and we didn't go down that path. Should there be a restriction on permanent members being prevented from voting on resolutions that concern their own conduct? I'm going to ask the naive question. I'm just going to pitch it straight down towards you. Could we add that now?
The only way you could add that, if you are on the UN Charter, reading a purely legal reading of the UN Charter, is to get the permanent 5 members to agree to not veto a restriction of their veto power. So, no. I mean, theoretically you could, but I'm unaware of any individual or organization of significant power who's willing to give that up freely.
No, it leads me to my 12-year-old's plan for UN reform. And Jamie wants to have a long conversation with you about the Security Council. He's outraged about it as a matter of fairness, but that, the only way to get rid of it would be to kind of shut the UN down and start up again in a separate building across the street and reform without the veto.
I have I have made that same argument in a 2022 paper. And my concern there is that at the moment you have the big powers inside the tent restrained by international law when they feel like it. If you do that, you have the big powers outside the tent not bothering to be restrained by international law because they don't feel like it and they have no benefit whatsoever to it. So that's about the only way you can do it. I agree with Jamie on that one. I just don't see it as making things any better, and I see it as, in at least in the short to medium term, making things a heck of a lot worse, and basically leading to the end of the interwar period.
Right. Well, that's a cheerful thought. But yeah, I take your point that even if compliance may seem patchy when we look at some of the permanent five, they've at least got a stake in the institution so long as they're inside the tent. And that's going to increase the likelihood of compliance, however you choose to judge that. All right. But people get very agitated when the Security Council does things or fails to do things in the manner they would approve of. So particularly in the context of the invasion of Ukraine, this argument's been floated that, well, no, the seat on the Security Council was given to the USSR. It was not given to Russia. And when the USSR dissolved, there was an empty chair. And perhaps Russia is not really the successor to the USSR seat on the Security Council and shouldn't be there at all. What's your reaction to that creative line of thinking about, some procedurally clever way of kicking Russia off the Security Council?
Well, my first one is that they're technically correct that Russia is not the successor to the USSR at a technical level. And I'll get to that in a minute. Mostly, I just wish that people would stop having those hot takes without their legal department interjecting and saying, no, please shut up. Because they are so dumb.
So this argument was in fact made, I believe, by the Ukrainian delegation to the Security Council at one point.
Multiple of times. And I really wish the lawyers would sit them down beforehand and say, yeah, no, it's not going to fly. And it's not going to fly for two very good reasons. The first is the Alma Ata agreements, which are filed. You can get copies and read through them yourself from the Council of Europe has them on file in digital copies. And on page 151 of the document that you can get from the Council of Europe, which is page 15 of the PDF, it says very clearly that this is the decisions by the Council of the Heads of State for the Commonwealth of Independent States. So that's all the states that came out of the dissolving of the USSR, have decided that, one, the states of the Commonwealth support Russia's continuance of the membership of the Union of Soviet Socialist Republics in the United Nations, including permanent membership of the Security Council and other international organizations. Literally there in the agreement on the breakup of the USSR is all of the states coming out of it going, yeah, Russia is the continuing of the USSR, not even a successor, it's a continuance. So It doesn't even have to deal with successor state treaty obligations. It's a continuance. It's an uninterrupted line under law. So we have that on the establishment of all of these states as independent from the USSR.
So just to sum up, essentially the kind of, the divorce or dissolution agreement of the USSR, all the independent or emerging entities kind of go, no, Russia's not inheriting anything. It is what's left over. It is the legal personality. There is a through line from the USSR to Russia. There is no break in legal status, and we're all fine with that.
Yes, that's exactly what they're agreeing. And even if they wanted to create some creative arguments about how that's not really what they agreed to, what we have is over 30 years of state practice and opinio juris, because it's been accepted within all of the UN bodies, including the Security Council, that this is legal fact, creating customary law that interpretation is the correct one of the UN Charter. So even if they want to create some retcon, that's not what we really meant 30 years ago. We've created customary interpretation of USSR means Russia in the UN Charter through uninterrupted state practice and opinio juris. It's a terrible take and it has no legal foundation.
Right.
And I'd like to slap certain presidents for constantly raising it without their legal team telling him to shut up.
And I mean, you've sort of framed it there both as a question of custom, but you've also sort of said continuous practice in the interpretation of a treaty, which is probably the route I'd take. When you've got 30 years of all the parties to a treaty, and the UN Charter is a treaty saying, this is how we think it operates, it becomes very difficult to argue late in the day that actually a different interpretation should prevail. All right, so the other one that's sort of cropped up a bit recently is the question of the membership of the State of Palestine in the United Nations. Now, I've phrased that very precisely because I think in a later episode, we will talk about the question of the statehood of Palestine. And I've used the phrase the State of Palestine because that is technically its legal name as it appears as a observer state in the General Assembly. So I'm not prejudging the question of Palestinian statehood here. The question that has come up repeatedly is, okay, the UN General Assembly has, by a significant majority, recommended that the entity called the State of Palestine be admitted as a member state of the UN. As has to happen, that recommendation went up to the Security Council. It floundered in the Security Council by the US veto, which I think was the only vote against. You can correct me if I'm wrong.
My understanding is the only vote against. There are a couple of abstentions from memory.
Right. And then there have been some interesting takes about, well, does the General Assembly really have to respect the view of the Security Council on membership admissions?
Yes. Yes, very clearly, yes. And noting that I like to think of myself as a sociologist who happens to also, with a great degree of shame and self-loathing, be a lawyer. Legally, the UN Charter is really clear on membership. There are a couple of phrases that aren't clear in Article 4.1, which is all other peace-loving states. So I'm pretty certain that there are a number of states that could possibly be well excluded from their continuing membership if we invoke peace-loving states.
Yeah, but originally, wasn't that just meant to keep out Japan and Germany until everyone was comfortable letting them back in?
Yeah, pretty much, which is why it's a case of, it's an interesting turn of phrase. It's one we kind of just pretend isn't there. But Article 4.2, which is the admission of any such state to membership in the United Nations, noting here that statehood is not tied to UN membership. Even from UN Charter, statehood is a requirement for membership, but membership is not a requirement for statehood. And that gets back to your later episode that you'll have with someone else.
I mean, just to underline that point really clearly, only states can be admitted to the UN.
Yeah.
But in order to be a state, it is not a requirement that you have UN membership.
That's correct. So will be affected by a decision of the General Assembly. So far, so good on the people saying, but the General Assembly can ignore the Security Council until we get to the end of that sentence, upon the recommendation of the Security Council. So the General Assembly only has legal authority to act on admission after there has been a recommendation put to the General Assembly by the Security Council. And because membership is a substantive question and not a procedural question, then the veto is in play.
Right. Did I read, might have been an argument by John Quigley that, and I thought this was intriguing. I'd like your take that, yeah, there's got to be a recommendation from the Security Council. Nothing says it's got to be a positive recommendation. The Security Council could come back and say no, and then the General Assembly is completely free to do what it wants. What's your take on that, if I've interpreted John's position correctly, and if I've traduced him, I'm sorry.
Well, my take on that would be, if it's been vetoed, then there is no recommendation. If it's been vetoed, then there is no resolution to provide the recommendations, whether it's positive or negative or completely apathetic. A veto means that there is no formal anything. It hasn't passed. There is no recommendation. So Yeah, if you can get it through as we think these people are awful, this state is awful and we don't really like them, but here's a recommendation that they're kind of awful and we don't think they're peace loving and we don't like them, the General Assembly could do what it wants. But I don't see that happening because, like, that's just absurd. And a veto means that there is a non-decision. There is no recommendation in one way or another if there's been a veto.
That's a really interesting point that I hadn't actually thought of. Yeah, no, thank you for that.
Are there any other things that I've missed on Security Council
No.
shenanigans?
You have answered very fully and thoroughly all of my questions on Security Council shenanigans.
All right, so I have a question for you, and there's a two-part question here, and we'll start with the first part, then I'll move to the second. So, what's your take on the allegations regarding Mossad attempting to intimidate the ICC prosecutor? Doesn't that sort of tomfoolery constitute a crime against the administration of justice? And how does this whole notion of crime against the administration of justice now affect all of the US senators and other members of Congress who are talking about sanctioning the ICC prosecutor?
Right. Okay. Yeah. So this is just a bizarre story, right? Like really quite jaw-dropping. But my sort of headline take here is that Yossi Cohen, the former head of Mossad, should just be slapped with an arrest warrant for offences under Article 7 of the ICC statute. And I'll unpack why that's the case, but he may have a statute of limitations issue that runs in his favour. But anyway, backing up. So in 2015, the then prosecutor of the International Criminal Court, Fatou Bensouda, opened a preliminary investigation into the situation in Palestine. Now, this apparently sparked some kind of full court press by the Israeli government. There was the intelligence operation, and there was also a team of lawyers led out of the foreign ministry who were also trying to engage with the court. So you had some sort of multi-pronged strategy of engagement. Now, part of this, though, appears to have been a Mossad operation to either try to recruit in the broadest sense of influence, turn someone to your cause, or intimidate prosecutor Bensouda. And if you look at some of the reporting around this, particularly in the Guardian newspaper, some of the details are kind of wild. But in particular, as I've said, Yossi Cohen, the former chief of Mossad, met prosecutor Bensouda in New York in this sort of bizarre ambush meeting facilitated by the president of the Democratic Republic of Congo, right? So she's invited up to speak with him, and a whole question about whether the court was too cozy with the powers that be in the DRC. But then he leaves the room and the head of Mossad walks in for a casual chat. Now, apparently, while he pursued contact and meetings with Bensouda fairly aggressively, and one of the more bizarre exchanges, apparently Bensouda like taking a call from him going, "How do you have my phone number?" To which he apparently replied, "What do you think I do for a living?" But the things really seem to have hit another level after the 2019 decision of Bensouda to seek a decision on jurisdiction from the pretrial chamber. So, there were the legal arm of the Israeli campaign had been aimed at persuading Bensouda that there were reasons to doubt the court had jurisdiction over the Palestinian situation. So she goes to the pretrial chamber and says, "Can you please rule on the preliminary question of jurisdiction?" So apparently from 2019 to the end of Bensouda's term, the Cohen interventions really go up a notch. And here's the key bit. In this period, he's alleged to have said, and again, this is just a journalistic report, "You should help us and let us take care of you. You don't want to be getting into things that could compromise your security or that of your family." Yes, the expression Tamsin is giving you on the Zoom call is appropriate. Now, when you hear that from Mossad, I don't think there's a lot of available interpretations. However, exactly when this occurred is important, because on administration of justice offences under the ICC rules, there is a 5-year statute of limitations. So if Now this conversation is alleged to have occurred sometime after 2019 or in 2019 or after. But like if it was before our current date in June in 2019, the statute of limitations is run. If it was after that date, really the Office of the Prosecutor should be getting an affidavit from Bensouda about precisely what happened and applying for arrest warrants very quickly if they're going to do anything at all. But in terms of things that involve the administration of justice, you're right, that's not all. Like on 24 April 2024, 12 US senators wrote to the court, including such luminaries of the Republican movement as Senate Minority Leader Mitch McConnell and Senators Tom Cotton, Ted Cruz, and Marco Rubio. And the critical paragraph of that letter to the current prosecutor, Karim Khan, was, "Target Israel and we will target you. If you move forward with the measures indicated in the report, we will move to end all American support for the ICC, sanction your employees and associates, and bar you and your families from the United States. You have been warned."
So they threatened KK with a good time.
Well, anyway, there's a great piece that I'd refer everyone to on Opinio Juris by Javier, and I'm probably going to mispronounce his surname, Escauriaza of Nottingham University on that whole thing. But then, the response from the Office of the Prosecutor put out on the service we're now allegedly obliged to call X was, "The office seeks to engage constructively with all stakeholders whenever such dialogue is consistent with its mandate under the Rome Statute to act independently and impartially. That independence and impartiality are undermined, however, when individuals threaten to retaliate against the court or against the court personnel should the office, in fulfillment of its mandate, make decisions about investigations or cases falling within its jurisdiction. Such threats, even when not acted upon, may also constitute an offence under the administration of justice under Article 70 of the Rome Statute." So, Tamsin, should we turn to what the Rome Statute actually says?
Yes, and I would like to ask an additional question. Has anyone been convicted under this? And also, it's just like Elon Musk to force us to dead name his website.
So I'll come back to who's been convicted, but Article 70 says the court shall have jurisdiction over the following offences against its administration of justice when committed intentionally. Paragraphs A through C deal with false evidence and witness tampering, the kind of stuff you'd expect. The critical bits for our purposes are paragraph D, impeding, intimidating, or corruptly influencing an official of the court for the purposes of forcing or persuading the official not to perform or to perform improperly his or her duties. Paragraph E, retaliating against an official of the court on account of duties performed by that or another official. And then there's a bribery offence in paragraph F. So the bottom line, attempting to intimidate an official of the court in an effort to persuade them not to perform their duties is a crime. Cohen's conduct as head of Mossad appears to plainly fit that. The US Senator's letter, look, I think it's probably also over the line, like as it threatens sanctions upon the prosecutor.
Would that letter, though, fall into the territorial jurisdiction of the state of Palestine, given the context?
Aha, great. So the territorial question is, the offences against justice part of the statute are a completely freestanding, separate regime, right? They're not tied to cases or situations. So where the territorial effects have to be felt is the seat of the court in the Netherlands, and a crime of intimidation, even under US law, as I understand it, a federal crime of intimidation or the like, can be committed by sending something through the post, right? So as international lawyers, we're familiar with this idea that we talk about subjective territorial jurisdiction when all the elements of the crime occur on one state's territory, but also objective territorial jurisdiction, the classic example being firing a gun across an international border. The state where the consequences of the crime are felt, where the final act is achieved, also has jurisdiction. And in this case, that's where the prosecutor received the threatening letter, right? So that is definitely the Netherlands. So a couple of interesting points here. One is, under the court's rules, like I said, there's a 5-year period of limitations from the commission of the offence. But then in Article 70, paragraph 4, there are some rules that essentially say, 1, every state party to the court statute must enact offences against the administration of justice by the International Criminal Court in their own code and must act on them if asked to by the court and properly resource that request. So there are actually two options here. The prosecutor could pursue this before the ICC or could ask the Netherlands to do it, which is really interesting. So has anyone ever been convicted? So this is also interesting. 4 people have been convicted in 2013 for administration of justice offences, and they were sentenced to 6 to 11 months each for witness tampering in the Bemba case arising out of the situation in the Congo. Now, Bemba himself, fortuitously, was also found guilty of witness tampering, including, I think, making calls like on the secure line from the detention facility attached to the court. And that was fortuitous because he was actually acquitted in 2018 on everything he'd originally been charged with. So having been charged with war crimes and crimes against humanity, in the end, all he was convicted of was witness tampering. So the ICC found Bemba and his co-accused bribed and coached defence witnesses. So they suborned the defence witnesses, right? And having them say that Bemba's troops weren't responsible for crimes committed during the conflict. Instead, it was army or rebel groups. And the sentenced accused included 2 of Bemba's legal counsel, which is just where I'm like, what? do you, anyway.
As an ethics lecturer, I was stunned to hear that. So,
yep,
yeah.
There we are. But the more interesting sort of thought experiment that could turn into like a Jessup Moot problem or an Armando Iannucci film or maybe a Quentin Tarantino film is what would happen if the prosecutor, just bear with this scenario, this is, I stress to listeners, not likely to happen. The prosecutor could, in theory, apply for sealed warrants for Article 70 offences, okay, against each of those 12 senators, then unseal them when he finds they're skiing in France. And then France would have to surrender those senators to the court for an administration of justice case, at which point, Tamsin, what favourite piece of US domestic legislation comes into play in order to liberate them from the horrible
The Hague Invasion Act.
Right. So there is a domestic law in the United States that authorises the president.
I think it requires, doesn't it?
Right. Look, I'm not a Hague Invasion Act specialist, but there is a law on the books in the US that says the US can invade the Netherlands to remove a US national from the custody of the court. So I think as a matter of realpolitik, it would be a high stakes game for the prosecutor to issue arrest warrants against US senators, but it would certainly be amusing.
Honestly, I want to see that movie made. I'd like to see Jason Statham acting for the court and The Rock doing the invasion.
Okay, yeah, no, right. So to everyone listening to the podcast, if you know any movie producers, we are now open for licensing rights. Okay.
All right, on to my other question, because I know we're running out of time. What's your take on the reactions to the request for Israeli leader arrest warrants when compared that with the enthusiasm for the arrest warrants against Putin?
Okay, right. So there's certainly been an amount of talk around, hasn't there been a degree of Western hypocrisy revealed by the fact that all the major Western powers kind of marched in support of arrest warrants for Vladimir Putin being issued by the ICC, and now they're taking a different approach now that Israel's in the frame. So one of our Twitter interlocutors, Alonso Gomendi at Oxford University, does a really great job of compiling the reactions of states to various things happening at the ICJ and the ICC. And honestly, I would suggest that overall the Western reaction is less problematic than I might have expected. So at the top of the list, we've got the USA saying it fundamentally rejects this exercise of jurisdiction, believes the ICC has no jurisdiction over Israeli nationals. That does not square well with President Biden himself having said that the warrant for Vladimir Putin was justified. Then there's the mostly rejects. And under this column, I've really got only the UK who described these decisions as unhelpful, then went on to say we respect the independence of the ICCC, but denied that the ICCC had jurisdiction in this case. And I mean, for reasons we've discussed before, I just don't think that's so. Then we have this interesting category of, how to put it, neutral but supporting the court, where statements came out stressing respect for the independence and the impartiality of the ICCC without expressly supporting the warrants in the Palestine case. In that column, we've got Ireland, Australia, Germany, and Denmark. But then we've got a small core of European states who expressed active support for the court in this situation. That's Belgium, France, Spain, Switzerland, and Liechtenstein. So I think the picture's a bit more varied than one might expect. But look, in the interest of time, I'm going to barrel on to introduce a new segment in which we respond to listener questions, which I want to call Sidebar, and which you, Tamsin, want to call Voir dire. So find some means of writing into us if you want to resolve that fight. In any event, Dor Hai wrote to us from Geneva to ask very politely if I hadn't made a mistake in discussing complementarity at the International Criminal Court last week. As he pointed out, I referred to Article 18 as a means by which Israel could have asked the court to defer any national investigation it was conducting. Now, while factually true, an Article 18 request has to be made within 1 month of the prosecutor notifying an affected state of a preliminary investigation, and that time limit would have passed in 2019. That means the action on this front has now moved to Article 19, which allows a state or individual to challenge admissibility before the court in individual cases one time only on the grounds laid out in Article 17. Now, the Article 17 test is exactly what we discussed in the last episode, and that's the same person, same conduct test. So that was an important clarification about procedure, but the substance of my comments last week were, I think, correct. At the end of the day, the way in which you've got to fight complementarity is same person, same conduct. And it remains irrelevant that you have a functioning judiciary. What you have to show to invoke complementarity is that you are genuinely investigating the same person for substantially the same conduct. Anyway, thank you, Dor. In wrapping up, Tamsin, I'm going to ask you the usual 3 questions. What recommendations do you have for anyone who would like to know more about what we've discussed today? What are you working on at the moment? And what is your current escape route? What are you doing or reading or viewing that takes your mind off international law? And on that 3rd question, I'm going to ask you to constrain yourself to kind of one thing, because you've got enough hobbies, and we can get into this in a later episode, for about 3 or 4 academic.
Okay, so recommendations on what we talked about. So, I mean, I've written a fair bit on the Security Council, which I think is fairly accessible, if a little granular at times. I'd also recommend depending on thanks, some of Gina Heathcote's work is fantastic, as is the work of Aoife O'Donoghue, particularly in her book, Tyranny and the Global Legal Order. She does a really fantastic study on the Security Council as one of the chapters, looking at her taxonomy of tyranny as it relates to UN Security Council operations. So there's a few options there. And as always, mind the footnotes. And on really substantive doctrinal legal questions on the Security Council, Nigel White's work is always fantastic and on point. What am I working on at the moment? Well, I've just sent, with my wonderful co-editor, Claire O'Hara, 2 books off to publishers that we're waiting on proofs and final queries on. So that's kind of done, but they're both on queer encounters and queer engagements with international law. So that's been a mammoth effort over the last 2 years, and we're really excited about that. And as a result, I am now trying desperately to finish up my law and literature monograph. So please stop sending me projects that are interesting so that I can focus. In terms of what my current escape route is, well, how did you frame it before we started recording, Douglas?
Oh, off air, I called it your staycation golfing holiday.
Yeah, so I've been on leave for the last 2 weeks, and I've managed to play 9 rounds of golf, and I think the light will hold after we finish recording this for me to go play another 9 holes this afternoon, and I've got about another 7 rounds booked in before the end of holiday, so I'm playing a lot of golf. I also cook, I DJ, I blacksmith, I read a lot of trashy steampunk fiction. Go read Gail Carriger's work. It's like the cupcakes of literature, and all delightful steampunk, enjoyable kind of urban fantasy-ish stuff. I believe one review said it gets unapologetically horny very quickly, if that's your thing. But yeah, so that's kind of what I'm doing to take my mind off it. I'm a big believer on have things that are not work that you can do to have as downtime, just because you can't pour from an empty glass.
And I think that's going to be a common theme in each of these episodes. Okay.
Yeah, so I have a couple of questions for you. First of all, Douglas, tell us what you're wearing.
Right, this appears to be becoming a standard question. So I'm wearing a blue 3-piece suit today, which is Suffered a bit of moth damage, unfortunately, during the COVID lockdown. So it is beginning to get a little small for me, but which I think of as an old friend. I'm also wearing that with a white shirt with a generous blue stripe and one of my favorite non-bow ties, a silk tie with stripes in dark navy, light blue, and bright orange. And I think the whole effect has a slight but not over-the-top 80s corporate executive vibe.
It does have a bit of that going on. And so my other question related to that is, when are you going to ask the Twitter menswear guy to do a critique of your sartorial elegance?
I am absolutely terrified of Derek Guy, the menswear guy, but he has brought me round to wearing high-waisted trousers with braces, so I should probably at least reach out to thank him at some point. And that's the end of the show. Thank you so much for making time for us, Tamsin, during your golfing staycation. And thank you so much, everyone, for listening. And we'll be back next week. Bye-bye.